Good evening, everyone. Welcome back. Tonight, we're going to discuss two heavy hitters. So, come on in. I will be reading off your super chats, and I'm about to post a link for any of you that want to come up to join the discussion. I'm going to post it for you. Just give me 1 second. We'll get that set up for you. All right, the link is posted for those that want to join the discussion. Come on in. Let's go ahead and get this party started. So tonight we're going to talk about Will Roundtree suing Jay Morrison's companies for copyright infringement. We're going to dig deep into this lawsuit. I'm going to show you the court papers, and I've invited both parties to jump on. Not sure if they will, but we have invited them. I'm actually going to go ahead and send them a message now. See if they want to jump on. If you know them, go ahead and tell Mr. Roundtree, Mr. Morrison, that they're certainly welcome to come in and give their perspective on this lawsuit. We're going to definitely be looking at some of the evidence and issues. Let's see if they come on. If not, that's fine. I will I've invited a couple of copyright lawyers up as well that may be joining us. And we'll see. We'll see who jumps on. All right. So we're about to see who's going to jump on, but we're going to go ahead and dig into it a little bit. Welcome on. Be sure to go ahead and say hello. Let me know where you're tuning in from. If you hear me great, press 1. Go ahead and comment 1 if you hear me very well. Very good. Welcome. Very good. All right. So tonight we're gonna talk about a lawsuit filed by Will Roundtree against Jay Morrison. Hello, everybody. Hello, Nubian DNA. Good to see you all. We're gonna dive right on into it. And thank you for supporting the channel. You're gonna see a lot more of me. I'm gonna try to talk to y'all a little bit more often. Haven't seen you in a while. So great. Glad y'all can hear me just fine. Excellent. Thank you very much. Excellent. So yeah, so some of y'all, I mean, most of y'all that are tuning in should know who these parties are, but let's go over who's all involved. So this here's Will Roundtree, and let's read up about him a little bit for those of you that don't know um, who he is. Um, it says he's an author, motivational speaker, and a financial strategist. This is his website, willroundtree.com. It says, let me make it a little bigger for you. It says he went from homeless to millionaire. And it says Will Roundtree has established himself as a staple in the real estate investment sector. His expertise has garnered him recognition amongst his peers and those in the community, equally as the founder and top grossing principal at WE Management. Roundtree has helped over 1,500 small to medium sized businesses get access to over $300 million in funding during a 2-year period. And then here he has a full bio speaking about him going from homeless to millionaire. It says Roundtree's road to success has been nothing short of miraculous. In 2005, Will left Milwaukee, borrowed $500, headed to the town that never sleeps, Las Vegas, back in 2005. Once there, Roundtree found the ruthless realities of living without a financial plan and bad credit. His applications were denied for housing, and this left Roundtree homeless and living out of his car. With this new dilemma at hand, Roundtree was inspired to diligently educate himself on personal finance and credit. He would walk into libraries and read book after book about credit laws, standard operating procedures, regulations, credit, and economics. Eventually, this led Roundtree to become a FICO certified credit consultant. In this role, Roundtree helped thousands of families successfully restore uh, their credit, purchase property, own vehicles for the first time without a cosigner, obtain credit cards, and secure business credit. More than a decade later, Roundtree tours the country as a notable financial advisor, author, and motivational speaker. Just recently, Roundtree added TEDx to his growing resume. Roundtree has led more than 700 workshops and seminars worldwide, consisting of an innovative curriculum he developed, and he's still in development of new advancements regularly. Additionally, Roundtree is ever present in his community. With the inception of his nonprofit, he helped to co-found Common Tree, help serve underprivileged children and families in the greater Las Vegas, Nevada area. But his giving does not stop there. Roundtree lends his time to a mentoring program, and in his first round of a brand new series called 50 Men. This series is dedicated to the men in his community who want to learn and apply that learning into personal finance, starting businesses, and creating generational wealth for generations to come. 50 women will follow. So that's the bio on Will's website. Speaking about his services center around credit, establishing credit, restoring credit, business planning, business funding. Looks like he has several services that you can book. But that's Mr. Roundtree. Press press 2 if you know Mr. Roundtree. If you're familiar with Mr. Roundtree, press 2 for those of you who are familiar with Mr. Will Roundtree here. Go ahead and press 2 if you know Mr. Will Roundtree. That's his intro. All right. Next, let's take a look at the defendant, Jay Morrison, the defendant's principal, because the defendants in this case are Jay Morrison's company. But let's look at Mr. Morrison. So first thing that comes up, he has a book called The Solution. But Mr. Morrison describes himself as a pioneer, an educator, an activist. This is a picture of him here. His About Me section on his website says that he is known as Mr. Real Estate, is a real estate investor, realtor, TV personality, entrepreneur, social activist, and CEO of the J. Morrison brand and the J. Morrison Academy. Now, the J. Morrison Academy is a defendant in this lawsuit. And we'll take a look at the J. Morrison Academy as well, which is an online wealth school and mentorship program. A high school dropout, at-risk youth, and three-time felon. Jay made a major life transformation for the better over a decade ago, and now uses his life experiences and personal story of triumph to empower and impact the lives of thousands of his academy students, troubled youth, ex-offenders, and real estate professionals. That's excellent to be able to turn around and do all of these things. Jay made it his mission since the beginning of his journey to teach the value of wealth building, home ownership, and financial literacy to those who were historically not provided this critical information. So that's just a short bio. I see Mr. Morrison online doing a whole lot of things. I'm sure that's not an exhaustive list, but that's his bio. As far as education, if you click on J. Morrison Academy, who's a defendant, let's see if it takes us there. I already have the site open, but this is the J. Morrison Academy. And as you see, it pretty much goes straight to courses. And if you click all courses and we scroll down a little bit, you'll see he has courses about content creation, public speaking, self-mastery, cryptocurrency, stocks, finances, commercial real estate, self-mastery, real estate mastery, business mastery, 12-step business, real estate business owner crash course, Cash Buyers Academy, Lord of My Land, JMA Elite, wholesale company, an ebook bundle, Black Millionaire Mastery, business bundle, apartment syndication, and then credit to cash. Now, you look at the credit to cash, you'll notice this has Jay Morrison and Will Roundtree. So we'll come back to that, because there's a lawsuit now saying that some of these course offerings involving Mr. Roundtree are unauthorized. So we see that here, and we see that it's $497. So if we click there, you see there's an option for someone to enroll for $497. And then you have as the instructor, Jay Morrison. Okay. Noticeably, we don't see anything on here once you click, but perhaps inside that may contain Mr. Roundtree, but at least here it uses his name as far as that webinar course. You see some other credit and real estate course here. And so a few other courses based on real estate. So that's J. Morrison Academy. Now, Credit is King is a topic in this book, and we see that's on Amazon here, authored by Will Roundtree. Looks like this book came out December 23rd, 2016. This is Credit is King, a book by Will Roundtree. All right. This book goes over credit score, credit models, how your credit's affected. So that's a book by Mr. Roundtree. So that's what we have there. All right. So press 3 if you all are familiar with Jay Morrison. Just trying to see who knows who. Press 3 if you're familiar with Mr. J. Morrison already before tonight. All right. All right. So press 3 if you know. Okay. So we have some people that know, um, that also know J. Morrison. All right. So tonight we're going to talk about the lawsuit. Apparently, a lot of people commented, messaged me and saying, "Hey, I thought these guys were best buddies." Well, that may or may not be the case right now, but right now they're both involved in a lawsuit. I'm sure you've seen Mr. Morrison involved in lawsuits with Tony the Closer, where he achieved a victory over that particular lawsuit against Tony the Closer for defamation. This is a new lawsuit that just was filed, and I'll pull it up, that is not um, initiated by Jay Morrison, but Jay Morrison now, via his companies, are defendants. So let's get into that. Let me I'm going to pull that up. We're going to go through that. So I'm going to post a link again for those that want to join the discussion. But for now, I'm going to pull up this lawsuit. We're going to go through it, and we're going to just decipher and see what exactly is going on between these two, or at least between Roundtree and these companies. We're going to take it all the way from the top, and we're going to walk through and see exactly what's going on here. I'm going to put this screen up there. So if my eyes are looking up, I have a screen up high, and then I'm down low here on my other screen. So let me post this link again for anyone that wants to join and give any input. I may let you in. You'll be in a waiting room for a second, but I may let you in. All right. So here's the lawsuit. This is filed in federal court. So right here, you see that this case was filed in United States District Court of Nevada. Two lawyers on the case, Eric Powers and Tiffany Hill. Eric Powers in Las Vegas, Tiffany Hill in Oklahoma. Now, the plaintiff in the case, like I told you earlier, is Will Roundtree. Will Roundtree is the entrepreneur that we spoke about earlier. He's an individual. So he's individual as a person, individual. He's suing J. Morrison Academy, LLC, and Morrison Holdings, LLC, and also Rose and Doe's. Okay. Basically, sometimes you see litigants sue other entities that are unknown, or persons who are unknown, and call them Rose and Doe. So that's that. So that's not an actual entity right now, but those are just placeholders. This case was filed just July 25th of this year, and it's in the very beginning stages. So there's, to my knowledge, as of lately, nothing that has happened since the filing of the complaint. I'm not even sure if Mr. Morrison has been served yet. I can pull that up and see, but I'm guessing that Mr. Morrison has not even been served a copy of the complaint, but the case has started, and technically the time starts ticking on when he has to answer within 20 days after he gets served. When I say he, I mean Jay Morrison's company is the company. So Jay Morrison personally, interestingly enough, is not in this lawsuit, but his companies are Jay Morrison Academy and Morrison Holdings. So let's go ahead and go through it. Let me make it. All right, make it a little bigger. All right, so starting off, the plaintiff is Will Roundtree, and for his complaint, these are his allegations. So the introduction says this is a civil action by a plaintiff. Well, all right. I'm just going to give you some commentary along the way here. You know, I'm trying to be as objective as I can. As you all know, I'm a civil litigator as well. I do a lot of cases on the civil side in federal court. So I'm familiar with pleading. So this is considered a pleading. And so I'm going to just, comment and give you my analysis as I read through it on some things. And so the plaintiff is Will Roundtree. Typically, what you'll see is after you name the plaintiff and call their name, you'll put in parentheses and basically paraphrase their name, to just be plaintiff. So throughout, when you see the word like plaintiff, what it's really referring to is actually Will Roundtree. So it's not done here where you would see parentheses plaintiff, but when we see the word plaintiff here, we're talking about Mr. Roundtree. But this is a civil action, and civil action just means it's not criminal. This is not a criminal case. This is a civil case. So civil is basically about money, or you trying to get someone to stop or to do something. So that's a civil action. And so the plaintiff, Mr. Roundtree, is seeking actual, statutory, and punitive money damages. So when you see actual damages, that means money for what was actually, any actual damages that actually occurred, money you can quantify. That's what actual damages are. So for example, say if someone took $20 from you or sold something that was yours 100% for $20. Well, if it's yours and they sold it and they didn't have permission, like a book, then you're owed $20. That's an actual damage. Now, a statutory damage is a damage that the law or statutes permit you to get. So say if the law says if you sell someone else's book, the statutory damage is $1,000, then the statutory damage would be $1,000. The actual damage would be the $20 for the book. All right. So, and then they're also seeking punitive damages. Now, punitive damages are a different type of damages meant to punish. So anytime you see someone seeking punitive damage, they're not getting money that's actually lost, but they're asking the court to award money to punish the defendant for their conduct, their alleged conduct. And of course, this case is against the defendants, J. Morrison Academy and Morrison Holdings. And again, here you usually will see, an abbreviation for the defendants, or collectively, you'll see in parentheses that they'll both be referred to as defendants. So that's something you can see here. And so they're being sued for copyright infringement of the copyright laws of the United States, 17 USC section 101, which is a federal statute, and violations of the Trademark Act of 1946. So basically this is a copyright and trademark case. I find it pretty interesting that, well, we'll see later that perhaps there are other claims that could have been asserted that were not, but we'll talk about that. Jurisdiction and venue. So jurisdiction and venue, jurisdiction is the power of the court to hear a certain case. Venue is where the case is being heard. So both of those have to be present. And here you see the plaintiff alleging that jurisdiction is proper pursuant to these particular statutes. Now, the only issue here is, it's saying, it's very conclusory. Um, Basically, these statutes, um, if you were to look them up, will say that any statute, any cases pursuant to federal law, this court has jurisdiction. But here, the draft of the complaint just went straight to it and said jurisdiction is proper under the statute. I usually like to see factual allegations and not just pointing to a statute to say it's proper, because if it's challenged, you have to go by the factual allegations and not just the conclusion that jurisdiction is proper just because it is under the statute. You have to have facts to it. But uh, most federal judges will certainly not have an issue with saying that federal copyright and trademark law jurisdiction, is proper. So the court has personal jurisdiction over the plaintiff in that the plaintiff resides um, in Clark County, Las Vegas. Now, this doesn't make any sense to allege this because clearly no one cares about the court's jurisdiction over the plaintiff. The court only cares about the jurisdiction over the defendant. So um, it's very strange for that allegation to be there, because a plaintiff submits to a court's jurisdiction by filing a lawsuit. So typically, when you talk about venue, you want to talk about um, the defendant, whether the venue is proper with respect to the action. And sometimes you can speak to that regarding where the violation occurred, but personal jurisdiction is not the same as the court's jurisdiction. So personal jurisdiction is whether the court can exercise powers over a defendant. So it's very strange here for them to allege that the plaintiff, that jurisdiction is proper over the plaintiff, because that doesn't make any sense. That's automatic. The plaintiff always submits to the jurisdiction by filing the case. So that's a little strange there. Venue just in this district is proper under 28 USC 1391B through C. Again, this is what's called a conclusory allegation. It really would not hold up if challenged. So I think Jay Morrison's companies may be able to have a field day defending this, because it doesn't have any facts to support venue being proper out here in Las Vegas or Nevada's federal court. There's no allegations here. Now, if you look at this statute, and I may pull it up for you, but it speaks about instances where venue is proper, but you don't see any facts here. Now, next it says, additionally, this is the judicial district in which plaintiff resides. Well, no one cares. Plaintiff's residence has nothing to do with venue. And let me just actually fully educate you all on this. The defendant's residence has to do with venue. Now, there's another instance where venue can be proper where the acts took place or where the plaintiff was injured, etc. But where the plaintiff resides has nothing to do with venue. And I'm going to show you. I really like, when I teach my course, Credit Mastery, I like pulling up the particular statute so that you all can really learn and follow along with the law. And so some of you may be aspiring lawyers or law students. So let's learn here. So I'm going to pull up something that's publicly available to you all, which is called the Legal Information Institute by Cornell. And so let's see. Let me add Let me add another screen. So let's pull this back. So I want to dig in a little bit about this venue issue because it's very important. You can lose a case if it's filed in the wrong venue. So it's very important to understand the the issue of venue because a defendant can actually um, try to get a case dismissed if the venue is improper. So let me share this other window. All right. All right, here we go. So this is something you all could find online. So you saw from that complaint, they were talking about venue being proper under 28 USC 1391 B 2 through 3. So let's read that. So 2 says, well, actually, let me just go ahead and give you all 3 venue options that would be proper. Okay. And so 28 USC 1391 B says a civil action may be brought in one, a judicial district in which any defendant resides, if all defendants are residents of the state in which the district is located. Now, this wasn't alleged to be the basis of the venue, district court in Las Vegas. I'm sorry, Nevada. So this is not on the menu today as far as an option. My guess is Mr. Morrison's companies are located on the East Coast, like Georgia, which is where he resides. So this one wasn't stated. Okay. So we're going to just skip that one because this is not what's alleged to be the venue basis. But they allege, or Mr. Roundtree alleged, that venue is proper under B2 and B3. So let's look at B2. B2 says a judicial district. So judicial district in this case is the District of Nevada, in which a substantial part of the events or omissions given rise to the claim occurred. Okay, so did you see any allegation to support that? Remember, I said earlier, you can't just say venue is proper under this statute because that's conclusory, but you need to have facts. So they would have to have alleged that a substantial part of the events or omissions given rise to the claim occurred in the Judicial District of Nevada. Now, did anyone see that in that allegation? Yes or no? They just jumped to the fact venue is proper because. So there's an or here. So or gives us another option, or a substantial part of property that is subject of the action is situated. Now, that's possible, but we don't have the allegation. But we don't have any factual allegations to support that a substantial part of the property is there in the District of Nevada. So again, I have, issue with the venue because there's no factual allegations to support the venue being proper in Las Vegas. I'm sorry, Nevada specifically. Now I understand that court may be in Las Vegas, but the district is Nevada. Specifically, it's called the District of Nevada. Okay, so that's very important. And so a lot of people will just skip past these small I don't call them small, but these procedural matters. But these are the kind of things that can really get a case thrown out of a court. So I think this complaint could use a little bit more factual allegations to support this venue because it's way out there in Nevada, and Jay Morrison's companies are located in Georgia. So I think more attention should have been made to the venue here. Um, all right. So next, so again, on number 2, I don't see there were no factual allegations to support it, period. And we'll continue to read and see if it's later, but in that section, it's not supported. So if I was, Jay Morrison, Jay Morrison's lawyers, focus on whether venue is proper. Certainly jurisdiction, subject matter jurisdiction, which is the court ability here, is proper. You have copyright and trademark allegations, but there's no question that that's federal law, and the federal court has authority to hear that case. All right, so let's look at 1391B3. If there's no district in which any action may otherwise be brought as provided in this section, okay, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. Okay. Now, you all recall there was one allegation about personal jurisdiction, but who was that regarding? Somebody? Who was that regarding? That was regarding the plaintiff. The allegation was regarding the plaintiff being subject to the court's jurisdiction, not the defendant. So you see a problem here. So all right, so so that's the first issue that I'm seeing with this lawsuit. It looks like the venue is questionable, with it being filed in Las Vegas. So I think that complaint can be attacked because of that. And let's bring it back up. I think a complaint can be attacked because of that. So that's something you have to look out for. And by the way, I don't represent either side here, so I'm trying to be objective. I'm gonna talk about good parts about the lawsuit, the bad parts, but my job really is I poke holes and see strengths, see weaknesses. But yeah, the venue seems to be problematic because it's just not supported. It's this conclusory allegations regarding the venue. All right, so the next section is about the parties. The parties are the plaintiff and the defendants. That's what the parties are. So plaintiff is an individual residing in Clark County, Las Vegas, and owner of We Management Services, a Nevada LLC. Now, what sticks out to me here is we're talking about We Management Services. Now, I showed you on Mr. Roundtree's website that he is the principal of We Management Services. I think it was We Management Services. Okay, so that was talked about. Not so sure why it is coming up here, but when you're talking about the parties, you don't really have a limitation. So you can go through his whole resume. I think that's fine, but it's just sort of interesting to see this LLC being mentioned, and it's not really a party. But again, it's not too strange. You can go on for pages to talk about the party. So no big deal. Plaintiff is in the business of providing business coaching and financial literacy products. Okay, that's plaintiff's business. Now, makes you wonder, who owns those products? Is it we, or is it Mr. Roundtree personally? Okay. So who actually owns this stuff? So anyway, we'll see. Plaintiff is in the business of business coaching and financial products. Upon information and belief, defendants are New Jersey limited liability companies registered to do business in Georgia, with their principal place of business located at 3355 Lenox Road in Atlanta, and registered agent located at 3015 RN Martin Street, East Point, Georgia. Now, when you see a lawsuit and they're saying upon information and belief, that basically is saying that the plaintiff who's alleging these things does not have personal knowledge on it. Now, again, I think this too is strange because you can look up business information and determine with certain specificity what kind of business you're suing. So in this instance, you have two businesses that can be looked up. But here they're saying that the businesses are New Jersey limited liability companies. So we're going to look that up. We can figure that out and know for sure. And so I don't know why it's upon information and belief, because you can actually find this information and assert it we're pretty much with certainty because it's public information. So let's take a look. Let's figure out where these businesses are. Let's take a look at that. Let me show you how you would look that up. Okay. So if you go to Georgia Secretary of State, let's just start there. We know that Mr. Morrison right now is based in Georgia. So let's see if these businesses are listed. J. Morrison Academy. Okay. So you see J. Morrison Academy here. And if you go to the right, you see it's active. Now you see here it says foreign limited liability company. That lets you know that it's not formed in Georgia. The foreign part means that it's really formed out of state. So it's looking like, okay. And then once you look up here, look, it says the jurisdiction is New Jersey. Make that bigger for you all. All right. So you see right here, it says the jurisdiction is New Jersey. Okay. So we see, according to public records through the Secretary of State, where that business was formed. And it being a foreign LLC means that it's registered in Georgia, but it was really started in New Jersey. And then you see that principal address. There's a record address and then an office address. And then you scroll down, you see the registered agent is Morrison Holdings LLC. Okay. Now, we have to look up Morrison Holdings LLC because that's also a defendant. So let's go back and put in Morrison Holdings LLC. Once you put that in there, you see again that company is active. It's a foreign LLC. You click it. That too is based in New Jersey. The registered agent for that business is Rashawn Mitchell over at the RN Martin Street. Okay. So once we see that, we really don't have to say upon information belief. We know, I mean, the information is there. You can actually obtain this information through a public record search like that. So, you really don't have to guess about that because that's something you can look up. All right. So let's keep pushing along. So those are the parties. And let's get into the facts of the complaint. The facts of the complaint are plaintiff contracted with defendants on or around June 2019 as an independent contractor to provide credit education related services and coaching to defendants clients. Okay. Now, here's a typo, perhaps, but you see where it says defendant apostrophe S. So that means one defendant. But which one? Or did you mean to say both defendants' clients? And so here again, this complaint is a little ambiguous there, because you say defendant's clients, but which one? And Harvey's saying maybe he wants to paint a good picture of himself. Okay, well, what do you mean by that? How is he painting a good picture of himself by? I mean, where is he painting a good picture of himself? So I'm not sure about that. But anyway, coaching to defendant's clients. So which defendant are you providing services to? Because you have two defendants, and defendant possibly asked, that means one defendant. So that's the issue there that I see in this particular complaint. Pursuant to the parties' agreement, defendants, and here we have both of them, would pay plaintiff a percentage of gross profits in connection with products and services sold by plaintiff during the term agreement. All right, so okay. Okay, this is pretty cryptic. Okay, pursuant to the agreement, defendants would pay plaintiff a percentage. Well, how much? How much? All right. So in the beginning, where you're talking about coming, okay. Well, okay, yeah, I understand. Yeah. So, like I said, I agree with you. When you talk about the party, you can really, personalize and show what this person is doing. So, yes, sure, Harvey, I do understand what you're saying. Just trying to give a full picture of who the plaintiff is. Sure. Sure, no problem. Should say sold by defendant. Okay. All right. You talking about we management. All right. So D Charles, what's confusing to you? I see a question mark. What's confusing to you? So, all right. So defendants would pay plaintiff a percentage. Well, how much? Why are we being so cryptic here? Why can't we say 50%, 30%? What's the percent? And of gross profits. Well, I'm not a financial uh, person or CPA or anything like that, but when you say gross profits? Is someone on here familiar with gross profits? Usually you would see gross revenue, because profits, well, anyway, profits is really tricky, because how do you know, how can you track a defendant's expenses? So anyway, but nevertheless, if that's the agreement, fine. But what percentage? This is really cryptic in the sense that it doesn't say what the percentage is of the gross profits in connection with products and services sold by plaintiff during the term of the agreement. Now, what products and services? Are we just talking about the credit, education related, and coaching? So, okay, those are services. And what products and what services? So again, that's pretty cryptic. So maybe they're going to explain it better later and explain what they're talking about. So on or about October 1st, 2020, plaintiff through his agent. Okay. what agent? Informed defendants of plaintiff's decision to terminate the independent contractor agreement pursuant to the contract termination provision. Okay. All right. So they had an agreement that started June 2019, and then October 1st, 2020, plaintiff through his agent informed defendant, look, I want to terminate it pursuant to contract provision. All right. Well, then we jump to the next year, July 20th, 2021. Plaintiff became aware that the defendants were offering plaintiff's products on its website without plaintiff's authorization. Okay. So perhaps the defendants had authorization during the term of that agreement, but once they terminated, the authorization stopped. But what they're saying here is the defendants continued to offer it without the authorization. So on that same day, plaintiff, through his agent, don't know who this agent is, issued a cease and desist notice to defendants regarding the book Credit is King, Transforming Your Credit Royalty. Okay. Authored by plaintiff. Specifically, plaintiff requested that the defendants immediately remove the book from its website. So, okay. So that's July 2021. Upon receipt of plaintiff's July 20th, 2021 cease and desist letter, defendants continued to list plaintiff's book for download on its website. Okay. All right. Now, it said it offered the book on its website. It doesn't really say whether it was for sale, if any money was being made, but so that leaves you to wonder if is this something where money is made, or is this a free download? Because it certainly makes a difference in actual damages if the defendants are without authorization charging for that book to be downloaded and not paying. So that's unclear here with respect to this. All right. So plaintiff owns and has the exclusive right to administer or publish the copyrights for his book, Credit is King. Plaintiff sells Credit is King for profit on various platforms. Amazon, that's where we saw it, in both print and audio formats. So we saw that clearly, that the plaintiff is selling his book, on the market. Now, we're going to jump from July 20th, 2021 to May 23rd, 2022. So this is near present time. Plaintiff became aware that the defendants were offering certain financial courses created by plaintiff on defendant's website for purchase without authorization. Specifically, the Credit Mastery video course. Now, the course is off for sale at $297. Now, I think when we saw it, was it $497? Let me take a look. When we saw it on here just now, all right. Well, we see credit to cash, which is $497. Let's see if do we have Credit Mastery still in here? Let me see, what did he call it? Credit Mastery video course. So I don't see that now. I just see the credit to cash with Jay Morrison, Will Roundtree. So I don't see that on the website now. All right. So, but it's listed. It was listed at least on May 23rd, allegedly for $297 with a regular price of $997. On or about May 23rd, 2022, plaintiff became aware that defendants were offering certain financial courses created by plaintiff as a component of defendant's RBC, Real Estate Business and Credit Certification course. The course containing plaintiff's content was being sold without plaintiff's authorization and was offered at a sale price of $697, regular price $8,000. Now, as of today, I didn't see that Real Estate Business and Credit. Oh, wait a minute. Real Estate Business Mastery Bundle is $5,028. Let's see. I don't think we saw that one, did we? As of today. All right. On May 23rd, 2022, plaintiff through his agent, who is his agent, issued a cease and desist notice to defendants regarding the Credit Master video course. Okay. So a cease and desist means stop doing something. Created by plaintiff. Specifically, plaintiff requested that the defendants immediately remove the course from defendant's website. So it appears as of today that's been done, because I don't see it on the website. Plaintiff's agent also requested an immediate accounting of all of plaintiff's products sold or offered complimentary on defendant's website since the date of contract termination. So that complimentary mention brings us back to that download, that book download. It makes me wonder if that download was inside of a particular course and given away. It's not clear. I think this lawsuit needs to sort of clarify what was offered complimentary. We just went over some things that were sold, but was that credited as King book? Is that a complimentary download? It's not really clear which it is. On May 23rd, 2022, last stuff going on May 23rd, plaintiff through his agent, this agent again, purchased the Credit Mastery course created by plaintiff and offered on defendant's website, Legacy University, Center University. Okay. The course included 24 online video lessons, all consistent of the name, image and likeness of plaintiff. Image and likeness are the same thing. So, okay. So this course, so basically the plaintiff had someone go and buy this course and sees that the plaintiff, Mr. Roundtree's name and likeness are being used in that course. The course was offered and purchased at the sale price of $297, regular price of $997. Okay, so this shows that on the inside there's still some materials being used that is the name and likeness of plaintiff, and apparently it's not authorized. On or about May 31st, 2022, defendants through their agent, who self-identified as the director of operations for the Legacy Center, communicated to plaintiff via email in pertinent part as follows. Please note that the team is actively taking action to remove all products from the original site and rectify the sales to share with you immediately. Okay. And so this is May 2022. And again, that cease and desist, when was that? May 2022. All right. May 23rd. Okay. May 23rd. Is that the first cease and desist? Yeah, the termination was back in October 2020, though. But the cease and desist was May 23rd. And then pretty quickly, by May 31st, defendants are saying, hey, we're gonna do that. On or about June 17, 2022, counsel for defendants communicated to plaintiff through his agent via email as follows. Perhaps, plaintiff's agent may be his lawyer. I don't know. As for the audit, I think my clients have taken everything down and are putting together the data in a way we can share. I think it will show my client didn't make anything from anything related to your client. but we will get that information to you. Oh, wow. Well, okay, interesting. Yeah, I'm always skeptical when people are saying what they think it will show that you didn't make anything. Well, either you did or I mean, why are you thinking that if you don't have the information? And why are you thinking that if it hasn't been put together yet? So this, if I was a plaintiff, I would be very suspect of this. So you're selling all this stuff, and even your agent purchased. So even plaintiff's agent purchased the course, but the defendant's lawyer is saying we don't think the client made anything. Really? Now we know that's a lie. We know that's a lie because it was just a purchase. But again, the way this is worded, putting everything together, so you're going off of partial information, and so it's a lie, but it's conditioned on putting everything together. So it's a conditional lie because it could be the truth if you're looking at partial information versus all the information. So anyway, if I was a plaintiff, I would be very suspect. Clearly, there's some money being made. But again, back to that contract, when you're splitting gross profits, yeah, be careful when you're doing agreements based on your your other party's profits, because you can't control their expenses and things. They can always they can cook the books, whatever you want to call it, and and start getting an email like this. I didn't make any money, didn't make anything from anything related to your client. I'll be very suspect of that if I was the plaintiff. On or about July 13th, 2022, after being informed by defendant's agent that plaintiff's products were being removed, plaintiff reviewed defendant's website and noticed that the products were still being offered. So that's July 13th. July 13th, plaintiff through his agent purchased the credit mastery course created by plaintiff and offered on defendant's website, Legacy Center University. See, we haven't even gone to that website. We have to check that out and see, because we were at J. Morrison Academy. The course included 24 online video lessons, all consistent of the name, image, and likeness of the plaintiff. Again, image and likeness, same thing. The course was offered and purchased at the sale price of $297 with a regular price of $997. So, okay, so everything's still going on. Now, a practice point, this right here, this paragraph 20 is like 1, 2, 3, 4 different sentences and allegations. This should be broken up, in my opinion, because how do you answer that? You're going to say deny? It makes it a lot of work to understand, and it makes it too easy for the person to deny. And technically you're supposed to go in and deny or admit each part, but I make it a practice to try to just break up allegations and try not to have one allegation with compound allegations within it. So one sentence that doesn't have a compound allegation within that one sentence, I think would be better in trying to sort of pin this thing down. All right. The parties have not executed a licensing agreement allowing the use of plaintiff's intellectual property by defendant. Well, okay. That's interesting, because I thought y'all had an agreement earlier about sharing gross profits. So which one is it? So I can understand if you say the parties have not entered into a new one, but doesn't that original agreement count as a licensing type agreement where you're saying you can sell my product and get a percentage? That's the type of licensing agreement. So that's interesting that they allege that they have not executed such a thing, because I thought that in the beginning they said they did. They didn't call it licensing, but they said you would take a percentage. The defendant will get a percentage of the gross profits. What percentage? I don't know. So I'm a little confused by this, saying that there's no license. They have not executed a licensing agreement, because it certainly sounded like they did in the beginning. Defendants have failed to provide any sales reports or provide access to company records for the purpose of determining sales and related financial data, thereby resulting in continuing financial harm to plaintiff. Well, that agreement y'all signed earlier should have accounted for how that would be done. First of all, and second of all, a lot of this stuff should be done electronically, but when you start dealing with splitting profits, that's where you come into problems. If you'd have had a affiliate link or a joint sale link that would just chop the money up for you, you could have avoided this. But now when you're talking about you can sell it and split the gross profits in a percentage that's unknown, at least not alleged in this lawsuit, you get situations like this. So hopefully, you all can learn from that mistake, in my opinion, on talking about splitting gross profits and no certain percentage, at least is not alleged in this lawsuit, because you don't know what you're ever going to get. No one's going to really open up their books to you in typical due course, especially when there becomes a conflict. Defendant's unauthorized use. Again, we have a singular defendant. Which one? Defendant's unauthorized use of plaintiff's brand had a detrimental impact on the commerciality of plaintiff's brand. Okay. I'm sure so he's about to explain it. Plaintiff was unable to benefit from the monthly growth of its products because the defendants intentionally diverted sales from plaintiff through its unauthorized use of plaintiff's brand. All right, diverted sales. Okay. Well, the defendants misappropriated the brand of plaintiff continuously since October 1st, 2020. Now, this is, when they said terminate. Okay. And is liable to plaintiff for damages associated therewith. Since at least July 2021, plaintiff through its agent has provided defendants with sufficient notice of infringement of plaintiff's intellectual property rights. However, the defendants have repeatedly infringed upon plaintiff's brand, creating consumer confusion and resulting in damages to plaintiff. Plaintiff through his agent has attempted to work with defendants to obtain a workable and common sense accounting of defendants. Again, which one? Defendants repeat infringement problem. By its actions, defendants have intentionally ignored the overwhelming evidence that provides it with actual knowledge of the infringement. All right. Defendant's action. That's singular. Which one? Were willful and done with the intent to obtain financial gain at the detriment of plaintiff. As a result of the actions and inactions defendants, plaintiffs suffered damages, including but not limited to mental and emotional distress, damage to reputation, and financial hardship. Yeah, and loss of revenue. All right, first claim of relief, 17 USC 501. Real edge everything. By providing plaintiff's credit scheme book on defendant's website, defendant have contributed to unauthorized reproduction and distributions of plaintiff's copyrighted material. Again, it's not saying was it sold or was it given away. Defendants have not acted reasonably or in good faith in response to plaintiff's notices of infringement. Defendants' acts of infringement have been willful, intentional, and purposeful in disregard of and indifference to plaintiff's rights. As a direct and approximate cause of defendants, again, which one is the singular? Defendants' infringements on plaintiff's copyrights and exclusive rights under copyright. Plaintiff is entitled to damages and defendants' profits. Which one? To pursuant to 17 USC 504B for each infringement. Alternatively, plaintiff is entitled to a maximum statutory damage pursuant to 17 USC 504C in the amount of $150,000 with respect to each work infringed or such other amounts proper under 17 USC 504C. Now, I'm not a copyright lawyer, but I haven't seen any allegation in here that any of these items were filed for copyright. I understand now he's an author; he automatically is the owner of it, but I'm not certain of this. The filing, I believe you have to have a filing to get the statutory damages. But again, I'm not too sure. We don't have our copyright lawyers on here, but again, it seems to just be an authorship where is ownership. So I'm not sure. I'm not understanding how they're getting these statutory damages if this unless they file this book for a formal copyright. But maybe it's not needed for a book. I don't know. We could pull that up and see. Plaintiff is entitled to his attorney's fees and full cost pursuant to 17 USC 505. Defendant's conduct, again, perhaps a typo, but they're talking about one defendant with this type of apostrophe S designation here. Defendant's conduct is causing and unless enjoined and restrained by this court will continue to cause great and irreparable injury that cannot be fully compensated or measured in money. Plaintiff has an adequate remedy at law pursuant to 17-502. Plaintiff is entitled to injunctive relief prohibiting further infringements. All right, so I'm gonna scroll down. Are they asking for injunctive relief? Yeah. Okay. Second claim of relief, 15 USC 1125 A1. Plaintiff alleges everything above. Defendants, so both of them, violated 15 USC section 1125 A1 by using plaintiff's name, image, likeness, and brand through the credit mastery course. Now, once again, we're talking about the brand. Was this brand trademarked? I have not seen any allegation to say that there was a trademark of this brand. So that's another thing that I'm looking at. We're talking about brand, but is it trademarked? Do you really own this brand? All right. And the RBC course in a way that is likely to deceive consumers to affiliation, connection, or association with plaintiff, with defendants, and or cause confusion about the nature or origin of the project. Defendants have infringed upon plaintiff's brand without authorization from plaintiff, resulting in damages to plaintiff. Defendants, which one? Defendant's action have been willful, intentional, and purposeful in disregard of and indifference to plaintiff's rights. Plaintiff is entitled to recover actual damages as well as profits received by the defendants as a result of the misrepresentation of plaintiff's brand and cost pursuant to 15 USC 1117A. Alternatively, plaintiff is entitled to attorney's fees and a damage award equal to 3 times the plaintiff's profits under 15 USC 1118. So again, all this brand talk, I have not seen any allegation to see that this brand was trademarked, registered, trademarked. So jury demand, pursuant to Federal Rule 38B, plaintiff requests a trial by jury. Plaintiff further requests entry of judgment in favor of plaintiff and against defendants as follows: for entry of judgments against defendants for damages, for the maximum statutory award for copyright infringement, a permanent injunction against defendants, enjoining defendants. Now here's the apostrophe S. It really should be just a S. And their respective agents, officers, agents, etc., from directly or indirectly infringing on any manner on plaintiff's respective copyrights or exclusive rights, including copyrights or exclusive rights under copyright and trademarks, with respect to intellectual property of plaintiffs. Now, again, I'm trying to figure out, are any of these, I did not see any allegation of any particular thing being trademarked. So that's a question there. And B, causing, contributing to, enabling, facilitating, or participating in the infringement of any of plaintiff's respective intellectual property rights, whether now or existence or hereafter created. Okay. Well, can't sue for future, but future creations, but I guess, technically you don't want to infringe on that either. for an order directing defendants to promptly forward plaintiffs' infringement notices to their subscribers. Okay. Not sure what that's going to do. For prejudgment and post-judgment interest according to law, for plaintiffs' attorney's fees, full costs, and disbursements in this action, and for other relief. All right. And so that was dated July 25th, 2021, signed by Eric Powers, a Nevada lawyer. So that's the lawsuit. Anybody have any questions about this? That's it. That's what's going on between them. My further input is I can see a right of publicity case going on here when you talk about using someone's name and likeness, because right of publicity allows you to recover monies that's made by someone using your name and likeness without your authorization. So with that in mind, I would if I were the plaintiff, I would consider a claim on that. I would consider perhaps amending this lawsuit to either include that, and also to include some venue type allegations, and in some parts where you're saying defendants apostrophe S, you have to change that to include both defendants, because there's some ambiguity there. Because if you were to even get a default on this, I think the judge would look at this and be like, well, what defendant are you talking about? You have, say, a defendants apostrophe S here and there. And I think that, it can cause an issue. Or it may not, it may slip through. So, but I do think the Morrison side certainly can take some issues with respect to venue. The complaint does state a lot of statutory allegations regarding trademark, brand, and copyright, but there's no allegation or indication that there's any filed copyright. Again, with books, I don't know that they're the author is the owner, but as far as statutory copyright provisions and trademark provisions, where the allegations regarding any registration to support that would be something that I would be critical of. Let's see. So Harvey says very sketchy. Okay. So so what do y'all think? I mean, just with these allegations here, who do you think is going to win just based on what you see here? If you think Roundtree will win this particular case, I want you to type in will. If you think Morrison's companies will win this particular case, I want you to type in J-A-Y. So at whatever point some of you watch this video, I just want you to type in, who do you think is going to win this case? Is it going to be Will, if you think the plaintiff will Roundtree, or will it be J, if you think it's J Morrison? So just type that in the comment section. No matter if you're watching it live or after the fact, let me know who you think will win. And let me know what you think about this complaint. Is it a good complaint or a bad complaint? If you think it's a good complaint, just type in good whenever you're watching it. Just in the comment section, type in good for good complaint. If you think it's a bad complaint, then just type bad. And so D. Charles says Will, he believes Will will win, but not the amount he's asking for. Well, he didn't really I didn't really see him ask for a certain amount. Well, I think you're right, because that statutory amount that he was asking for up in the complaint, he's not going to get. But once you look at the section where he's praying for the relief, I didn't see any numerical amount. So, but okay. But thanks for your input there. Let's see. Okay. All right. So yeah, so all right. So yeah, so you all let me know if you think Will win by typing in Will in the comments whenever you watch this, or if you think Jay's companies will win, just type in Jay. And if you think this is a good complaint, if you think it's a solid complaint as far as the way it's drafted, I want you to type in good. And if you think it's a bad complaint, type in bad. And if you want to add any reason, you can just like D Charles did, just do a little dash and let me know why. Why do you think Will win? Why do you think Jay will win? Why do you think this is a good complaint? Why do you think it's a bad complaint? Just go ahead and put it in the comment section, and I will, I may share it on my Instagram and social media. So yeah, we'll take it like that. And Harvey says it all depends on the initial agreement between both of them, and I agree. I agree. It will be dependent on that ultimately. Um, and what do you think? The complaint is sort of real cryptic. It says a percentage. What percentage is really a cryptic? Is quite a cryptic complaint. It really leaves things very open. If you have an agreement, the terms should be very certain. Why didn't they um, be more specific on the terms? So that's something that stood out to me as well. And so, yeah, I'd be interested to see. But yeah, you all be sure to comment who you think will win, Will or Jay, and also whether you think the complaint is good or bad. Okay. Um, let me check and see. It looks like see if we got any commentary from our parties. No, doesn't look like. It does not look like any of the parties are going to come up to speak, and we don't have our trademark lawyers uh, chiming in, and that would be a good opportunity for them to talk to y'all about trademark, but they did not jump in. Okay. D. Charles says, "Do you think it's an open complaint because it's out of the area his attorney normally practices?" That's a pretty good question. I'm assuming when you say open complaint that it's vague. Yeah, I don't know. We can look up this lawyer and let's see. Let's take a look. Let's look up this lawyer and see if this is his practice area. Eric S. Powers. Let's see. Eric S. Powers. All right, ericpowerslaw.com. Let's take a look. Let's take a look and see. Yeah, well, nothing came up so far. Let's okay, well, Eric, let's see. Powers Law. Let's see if this is the same person. Eric S. Powers. All right. So first of all, on the complaint, it says ericpowerslaw.com. When you go there, that doesn't work. So I'm going to stop sharing and we'll pull up the lawyer's website. Um, like I was saying, the website ericpowerslaw.com, when you put that in, ericpowerslaw.com, nothing comes up. But when you Google Eric Powers Law, this comes up. And when you click the about, it says Eric S. Powers. And so let's go to contact. Let's see if this is the same address. Yep, 2640. So Suite 200. So this is okay. So here's his website. So perhaps this is an email only website, and this is the actual website. So this is the website of the lawyer who's representing Roundtree. And if you go to services, let's look at his practice areas. So his practice areas are slip and fall, aviation, product liability, construction accidents, asbestos, work-related injuries, motor accidents, class actions, wrongful death. And this must be a picture of him here. Interesting, a 312 number, because that's I think Chicago. But you make a good point, because it certainly does not look like this is a copyright lawyer. And perhaps that may explain some of the questions that I have regarding these trademark and copyright statutory requests. So yeah, so based on his website, this doesn't appear to be the kind of lawyer that you would expect to be doing a copyright trademark case. Like, for example, that area is a pretty specific area with its own set of laws that are completely different. Even though it's civil litigation, it's a whole different area that a lawyer could become competent with enough to litigate. But I would certainly feel more comfortable doing it with someone experienced in that area. But and also keep in mind, attorneys focus on certain practice areas and may advertise those areas on their website, but that does not mean that he is not up to speed on copyright trademark law just because it doesn't advertise that on his website. So but I understand the question, and I think that is a good inquiry to make, because there are some things that I find to be questionable about the complaint. So I think Jay Morrison will just pay Will Roundtree to keep him quiet. Well, he's not quiet anymore, so might be too late to keep him quiet. But clearly, if there was a termination of the agreement and some sales were made, they may be a payment due. But the way that contract is written, allegedly talking about splitting gross profits, then that could be some issues, because profits come after expenses. And Will was a major factor in this business. Okay. So yeah, you would think that would count for something, right? All right. Well, I'm gonna wrap it on up. Again, whenever you all see this, let me know who you think is gonna win this, Will or Jay. And the complaint, is it a good complaint or is it a bad complaint? Just leave it in the comment section. I don't want to hear. I just want to take a little poll. I'll be looking at this, after the views, and see what y'all think. All right. Thanks for tuning in. Be sure to like the video and comment. Like I say, comment. Let me know who you think is going to win, if it's a good or bad complaint. And be sure to subscribe. and share this video with someone. Let's get the following up. So be sure to subscribe, and I'll continue to talk to you all about these, things that revolve around credit, finance, debt, and real estate issues and other legal issues. So support the channel, and I'll keep these type of videos coming. All right. Have a good night.